is Aviva Breen, and I was asked to speak here today as a member of the Supreme Court Task Force for Gender Fairness in the Courts. Perhaps I should have gone before Ms. Anderson. Just a little history lesson, and I'll start with an anecdote. The very first time I ever came to this Capitol to talk to lawmakers was in the middle 70s to lobby for the ERA. So,
well, and you're still here.
Yes, here I am again. So I feel like I'm 35 years younger. The task force was established in 1987 and completed its work in 1989. And the mandate of the task force really was to explore the extent to which gender bias exists in the Minnesota state court system by ascertaining whether statutes, rules, practices, or conduct work unfairness or undue hardship on women or men in our courts, document where found the existence of discriminatory treatment of women or men, litigants, witnesses, jurors, and of women, judicial, legal, and court personnel, recommend methods to eliminate gender bias in the courts, including the development and provisions of necessary judicial education, the passage of legislation, and the promulgation of court rules and policy revisions, report the findings, and then monitor the implementation of the approved reform measures and evaluate their effectiveness in assuring gender fairness in the courts. And I will say that this report was submitted in 1989, and the very forward-thinking then Chief Justice Amdahl immediately appointed an implementation committee. I did serve on that committee for 20 years, and then I decided it was enough, so I did go off last year. But the work is still being done and is continuing, and there are reports, and obviously progress is being made, and some progress isn't being made, and it's an ongoing process. Interesting. There was a lot that was very interesting that was learned, and I won't go on about all of it, but one aspect that really speaks to the ongoing problems is that there was a huge difference in the response of female and male, between female and male attorneys, female and male judges, to some of the questions that the task force surveyed, and in their perception of whether gender bias in the courts existed. For example, half of the male attorneys, but only 9% of the female attorneys, said that they had never seen gender bias exhibited in the courtroom. And similarly, in response to a question about attorneys' perceptions of gender bias against women, at that time, 48% of the female attorneys, but only 10% of the male attorneys said that gender bias in the court was widespread, but subtle and hard to detect. So the perceptions varied according, apparently and obviously, to which side individuals were on. And there is ongoing work that's been done and progress in a lot of areas, but the areas of perception, and particularly in this context of those who are intimately involved with the court system, have to change over time, but of course new people come in. I mean, the advantage of having a constitutional bar that is high enough to indicate that this is an important distinction that the courts and that individuals in society and any public entity represents gives notice that the standard will be higher, and that inability to operate within a system that isn't discriminatory will result in an action, and that the decision to do something that is discriminatory, regardless of what one's perceptions are, will be looked at in a much more serious manner. So that was what the task force was trying to look at and has been trying to continue to review over the years. Much of that bias has changed because of the participation and because of the perception and because of the continuous review. But creating a constitutional standard that will exist, I think, just simply sets that bar high enough that more attention will be paid for it, and adds to the ability to overcome those perceptions and biases, which have real results for real people.
Thank you.
Thank you.